All right. Good afternoon. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace, and I'll be presiding over this case at 2:30. I also have joining me on our panel, Judge Jay Cohen from Orange County and Judge Eric Eisnagel from Seminole County. We have one case on the docket here at 2:30. It's Rachel M. Sadoff et al. Versus the Board of County Commissioners, Brevard County et al. And I have been advised that we're having a little bit of an issue with the Wi-Fi at the courthouse. So we're going to be keeping we're going to have two timekeepers. We're going to have our clerk, our marshal's office keeping time, but I'm also going to keep time as well. And I'm going to assume, Mr. Hull, that you want 20 minutes. You have 20 minutes. I'm going to assume that you want 5 minutes for rebuttal unless you request another amount of time. Just ask that all the parties go on mute when you're not speaking. And that way it won't be a disruption if there's any background noise or anything like that. So with that, Mr. Hull, you may proceed.
Thank you. Good afternoon. I'm Brian Hull on behalf of the appellant, Rachel Sadoff, as the Brevard County Clerk of Circuit Court and the Comptroller. And 5 minutes for rebuttal would be fine. Thank you. This is an action to interpret a provision of the Brevard County Charter. The trial.
Mr. Hull, let me. We're familiar with what it is and the background. So let me start by talking a little bit about the complaint. In the complaint, you say that the county has taken the position that the excess rate shall establish the baseline for purposes of calculating the following year budget, but you don't cite really to exactly how they've taken that position, and that really goes into the argument as to whether we have an actual dispute or whether this is just theoretical. So how do we know that the county intends to do that? Have they actually done it, or is this just something that's been talked about?
No, they have actually done it now at this point. At the point we filed the complaint, it was an issue that had been discussed, and the parties' positions were very clear on what they were. The clerk
but at that point in time, they hadn't actually done it. So let's assume, for the sake of discussion, and of course, there's some other issues that we're going to address as well, that there wasn't an actual case in controversy at the time of the initial filing. You're suggesting that if we were to allow you to amend, there is such a case in controversy at this point.
Yes, Your Honor. And in fact, this position has made its way into the budget in the past when the charter cap had been busted on prior occasions. And so
I don't know that that's really in the record, and that it would be neither here nor there. And so then, assuming that we have a case in controversy, then the next issue becomes the authority of the standing of the clerk to bring this issue. And I don't really want to spend a lot of time on the public official standing doctrine. I'd like to just go beyond that and talk generally about whether the clerk's function is to address expenditures rather than the setting of millage rates or the setting of a budget by the county commission.
Sure, of course. And in this case, in the trial court's order dismissing the complaint for lack of standing, the trial court focused only on the clerk's limited statutory responsibility in preparing the tentative budget, which was not the role that the clerk relied on for her standing. The clerk has multiple other roles conferred under the Florida Constitution and the Florida statute. The clerk is the county's auditor and the custodian of all county funds. And the clerk is the one, as you have mentioned, who is responsible for dispersing the funds of the county. And the charter provision that's at issue here set a cap on the annual increases in ad valorem taxes the county can impose. And that cap can only be exceeded if a supermajority of the board makes a specific finding that the excess amount of tax is necessary because of an emergency or a critical need. And it specifically says that finding is only valid for a single budget year. And so the clerk sued to file this suit to ask, what does that subsection C that sets that exception, what does that mean? Does it mean that the excess amount is permanent, carries forward into every single
Counsel, we understand all that. I think we're pretty familiar with the procedural background and sort of the issues in play. I think Judge Cohen's question is an apt one, and I'd like to know the answer as well. And I think the question is, clearly the statute contemplates that the clerk will police, for lack of a better term, oversee expenditures, has jurisdiction on expenditures, and should not authorize any expenditures that are illegal. However, it's not clear to me from reading the statute that the same applies to a determination of revenues. And it seems to me those two things could be very different issues. A determination of expected revenues versus, once those revenues are determined and duly passed into the budget, then how those funds are then spent, right? So could you point us to anywhere in the statute or any other legal authority that might establish the clerk's authority over revenues?
Sure. The Constitution makes the clerk the county's auditor. And in a constitutional role of the county's auditor, the clerk has the authority to audit the county funds, including the county accounts as well, and determine what amounts properly belong to the county. And the question here is, if the county's interpretation of this charter provision is wrong, and the collection of this excess.
Where does and by the way, I from scouring the legal authorities, it seems like that might be your best argument, pointing to the word auditor, right? But make the connection for us. Why does that not mean auditing the budget as passed by the county commission to make sure that the funds are spent in accordance with that budget and with other state statutes, for instance? But why should that word audit automatically be extended to sort of a function of overseeing the board of county commissioners estimated revenues as well?
There is nothing that places the limitation on it to simply the expenditure side. The clerk is a constitutional officer with a duty to protect the public funds. And part of that duty is ensuring that the county doesn't spend money that it doesn't have. The clerk
Mr. Howell, what if hypothetically they collected the money and didn't spend it? Now I know, government doesn't work that way, but what if hypothetically that occurred?
Well, then that's the question. If in the clerk's role as the custodian of the county funds, the clerk has to take custody of this excess ad valorem revenue that's at issue here and has to maintain custody over it. And in that custodial role, and combined with her auditor role, the clerk has the authority to look into, is this revenue that properly belongs to the county or not? And therefore, extending to the expenditure side, is this something that she can expend because it properly belongs to the county?
Can you point to any?
Go ahead, Judge Weisman. Sorry.
Other than the word auditor, can you point to any legal authority in the statute, case law, anything that interprets the word auditor so broadly?
The cases that have been addressed here, the Alachua versus Powers case, dealt with the auditor function in the role of the expenditures, because that's the issue that was before the court. We also cited the Barat case. And in that case, the court made very clear that if a public official is given a duty to accomplish a public purpose, then by implication, they have every power necessary and proper to perform that duty. And in that case, the clerk's custodial and audit roles gave the clerk the power to investigate whether funds properly belong to the county, even though they are outside the clerk's custody. And I would say that by analogy, the clerk here also has the power to investigate.
That wasn't counsel. Neither one of those cases involved a dispute over whether revenues were proper. The first Powers was an expenditure case, as you acknowledged, which I don't think anybody disputes that expenditures clearly fall within the clerk's jurisdiction, right? And the second case you discussed had nothing to do with whether or not a revenue was proper. It had to do with who should have custody over the the funds, the county funds, right?
That's right.
So
That's
neither
right.
neither one of those cases gets you to where you want us to go with the term auditor, correct?
I would point you then to the Green versus City of Pensacola case. That was a case where the state comptroller filed a lawsuit asking to declare unconstitutional a special act that exempted the city of Pensacola from paying gross receipts tax on sales of natural gas. It addressed a question of whether the state could or could not collect a particular source of revenue. And the city there had argued that the comptroller had no duties under that special act and was not affected in his personal property or other material rights. The court found that he could still sue, not only because he was responsible for collecting the revenue, but also because he had a duty to take custody of it and a duty to disperse it. And that's similar to what we're looking at here, although, again, we're not talking about the constitutionality or validity of the case, and that was a public official standing doctrine case. But in this case, the clerk is still allowed to ask that interpretation of this provision because she has to take custody of those funds, has the ability to audit them, and ultimately is the one that has to disperse them.
Could she not have brought this, in an individual capacity, just as any citizen of, Brevard County could do the same?
Could she have? She did not bring the suit in an
I
individual
know she
capacity.
did, but she certainly could have, couldn't she?
She could have, yes.
And any citizen of Brevard County could bring an action similar in nature, right?
Perhaps if they meet the standards for taxpayer standing in a case like that.
Well, I think both Harris and Evander would meet that, wouldn't they?
Perhaps.
Counsel, is there any, I mean, not that it's dispositive in this case, but is there any dispute that there are taxpayers that could have brought this and standing would have been clear?
I don't, that's not an issue that has been raised in this case. Is it possible a taxpayer could have raised this issue? Perhaps it is, but that's not something that's in the record or that has been put at issue.
Because the reason that we're talking about that is because of this issue of what the role of the clerk is when you bring it in under the name of the clerk of the court. That has ramifications to it, and it has to do with her constitutional obligations and authority, and that's I think what we're struggling with.
And I would just continue to point to the fact that she's the one that has to take the custody of these funds and has the ability to audit them and ultimately has to expend them. So she would be the perfect person to challenge whether or not these are funds that actually, in fact, belong in the county coffers.
So does she have to expend them? I mean, it seems like perhaps you're correct that she would have to take custody if they're collected, right? Perhaps, but would she have to expend them?
That was one of the things that she had pointed out at the motion to dismiss hearing, where she was asking the court, I would like a declaration of whether or not we have to impound these funds or whether or not we can expend them without violating our duties.
But see,
Go ahead.
That wasn't really my question. My question is does she have to approve expenditures of these funds?
I think she does. If they are presented to, if the request, the appropriation is presented to her, then, and it meets all other statutory requirements, I think she's in a position where she does have to expend them.
Statute says if the expenditure is illegal, that she not only has the discretion to decline to do so, she must decline, right?
That's right. If the expenditure is illegal, yes.
So is the expenditure illegal then?
I think that's what she was asking the court, and why she filed this action was to determine, is this an expenditure that I can lawfully make or not? And that was the cause for the uncertainty that led to file this action.
Well, I think that's a basis. That's an issue of the basis of the expenditure. I mean, you certainly, if the expenditure is for, parks or sheriff's office budget or other things, certainly then that's an authorized expenditure, I think, is the point you're trying to make, versus whether the funds were collected in a lawful manner. That's the distinction you're making, correct?
Yes, and that's the question. You know, when we have appropriations that exceed the amount of this amount of revenue, that calls it into question. Now, once we've crossed that line, are those funds that can indeed be spent or not if they were collected in violation of the county charter?
Briefly, let's talk a little bit about the position of Applee that you didn't file a motion to amend. I'm assuming that you did not do that because the lawsuit was dismissed with prejudice.
That's right. It was dismissed and the court did not grant leave to amend. Our position is that we did all that we needed to do at the hearing. The clerk specifically offered to amend the complaint on any specific points the court might raise in ruling on the motion, and offered to do it very quickly. And we've cited to a number of cases where
I understand, but the reason that you didn't do that then was because the court accepted the invitation by the appellee and dismissed it with prejudice.
That's right.
Okay.
That's right.
All right, you've got 5 minutes left if you'd like to,
Thank you. I'll reserve for rebuttal.
Okay, Ms. Girondi,
Yes.
you have the floor.
Thank you. May it please the court. It is the Brevard County's position that it is the Board of County Commissioners that is the taxing authority under 2.9.3.1 of the Brevard County Charter. So clearly, looking at Florida Statute 129 and Chapter 200, the clerk of court does not have a role or a duty under those statutes to impose a millage rate or levy ad valorem taxation. Brevard
So,
County,
Ms. Girondi, which government entity in Brevard County has the ability to challenge the setting of the millage rate above the standard rate in this case? Who could bring that cause of action?
it would be a taxpayer action. A taxpayer who met the requirements under Florida Statute 197 could bring this case. And actually, in the
So just being a public official is insufficient to establish standing to challenge the setting of this excessive millage rate. Is that correct?
Being a public official, there are limited exceptions as to why they could challenge a law. So they would have to fall into that public official standing doctrine. So essentially,
that addresses the constitutionality of statutes. It doesn't. I'm not convinced it applies under these circumstances. So the clerk could have brought this under in an individual capacity as a taxpayer.
That is correct. But I would submit to the court that in the case of Markham, two things happened there that might be of interest to the court. Is one, Markham, they filed in their official capacity and as a taxpayer. So I believe, if I recall correctly, that saved that case because there was that dual role that was actually filed. As well in Markham, the court found that even though at the Florida Supreme Court level, the challenge wasn't the constitutionality or validity, but it was to get an interpretation. The Supreme Court said because
why shouldn't she have been allowed to amend her complaint then?
She didn't ask.
She did ask. That's nonsense. That's nonsense. She asked repeatedly during that hearing for the to amend, and and your client talked this trial judge into a dismissal with prejudice. And at that point, the case is done, and and there's no leave to amend. So I'm sorry if you're arguing that they didn't preserve a right to amend this. You're going to have to convince me of that because I certainly don't see it.
Respectfully, Your Honor, in the transcript, there was no actual request to the court. It was conditioned upon the word if.
Well, you don't amend a complaint if it's not dismissed. There's no reason to file an amended complaint until the judge grants your opponent's motion to dismiss.
And respectfully, Your Honor, they at that time, if you take a look at the trial court's order, nowhere does it address a request to amend the complaint. So at that time, if the
but that's the order dismissed it with prejudice because that's what you convinced the trial judge to do. When under the rule, they had a right to amend this complaint.
And I would submit to the court that under Florida Rule of Procedure 1.530, if there is an error in a trial court's order at that time, they could have filed a motion for reconsideration within 15 days and brought that error to the trial court. I think it's first,
Counsel, we probably shouldn't spend too much time on preservation, but let me just on that, let me note two things. Number one, I agree that they didn't raise this in an artful way. It was inartfully raised. That said, the law on preservation is clear that magic words are not required. Do you agree?
I would agree, but I would also agree that how does the higher court reverse a lower court on an issue that they never ruled upon? The order is silent.
That leads me to my second point on preservation. And the second point on preservation is that all preservation requires is that a party give the trial court an opportunity to address the specific issue. And so in this case, assuming that the inartful attempt to ask for an opportunity to amend was sufficient, that put the trial court on notice of the very specific issue, the opportunity to amend and the fact that they could do so. And so I think I don't see this as one of those.
Oh, I'm sorry, you froze.
Yes, you did. But he looks good.
There he is. You're back.
Oh, all right.
Am I back? Okay.
You're back.
So this doesn't strike me as the kind of case where a motion for a hearing is required, because those are cases where the error appears for the first time in the judgment or the final order.
And once again, I respectfully disagree. I think the cornerstone of appellate law is that you give the trial court a chance to rule on that issue. And
I'll tell you what, you walk this trial judge, you convince this trial judge to enter an order that dismiss this with prejudice, and now you want to seize upon preservation, and it's in my mind that's disingenuous. So let's move on. Let's talk about I'd like to spend a little bit of time on the substance of this, which is you've got this 2019 ad valorem taxation right, in which the county commission imposed excess of what the charter called for by making a finding that it's an emergency of critical need. It shall set forth the ultimate facts upon which it is based and shall be valid for a single budget year. What the county commission now is attempting to do is to take that baseline and use it on a going forward basis in perpetuity. Why doesn't that completely eviscerate the language? It shall be valid for a single budget year. Going forward, you don't address that one-time assessment, you've made it permanent, have you not?
actually, respectfully, Your Honor, the 2.9.3.1 of the code of the charter essentially is broken into 5 sections. And the section you're referring to is subsection C, which talks about the finding of critical need shall be valid for a single budget year. You have to look to subsection D and the clear language of that section.
You're using a general provision when there's a specific provision that addresses something. You know, you've got a general provision on what can be excluded, and then you've got a very specific charter provision which says it shall be valid for a single budget year. And the specific always is going to control over a general provision.
But subsection C is about the finding by the Board of County Commissioners.
That's beyond more than that. It's beyond how long you can impose this additional burden on the taxpayers of Brevard County, because that's what you're doing.
It is the clear language of the charter. I think any rewrite by the court would be a separation of powers issue.
Oh, no, the rewriting of it is by your interpretation of it. We're going to interpret the words just as they're written. And we're not, your interpretation completely wipes out the single budget year language in that provision.
What I would propose is if what the clerk is proposing that language to actually include would have to be in subsection D, and it is not found in subsection D. Subsection D tells the county how to calculate the allowable increase in ad valorem revenues over the ad valorem revenues budgeted for the previous year when you have that finding. So
You
that's
agree then that special, that the ability to increase more than the 3%, which was done in 2019, stays in that county budget forever, does it not?
I would agree, yes, because we are
Okay.
not told to take
And
that out.
then you've taken that language that says it's for one single year and you've completely ignored it or eviscerated it.
The charter does not tell us to remove that in subsection D, so I'm following the charter.
Counselor, your argument is that C doesn't mean that that emergency or urgent bump in revenue goes away. It just means that the finding goes away, and that if you want to do it yet again, you have to have that supermajority vote. That's your, and I'm not taking a position on what the correct reading is. I'm just saying that's your reading of it.
That is correct. That is our reading by the plain language of that subsection.
Now, look, but we don't even get to that in this case, right? We can't get to that issue in this case.
No, Your
Yeah.
Honor. At this point, we're at standing, and the reason why the complaint was dismissed.
So, counsel, could you respond to counsel's argument? Two arguments. Number one, the argument that the clerk has standing because the clerk will be required to take custody of the funds. I note that I don't remember seeing that argument in the initial brief. So that might derail that argument by itself. The fact that if unless it was in there and I'm just forgetting. But then the other argument that I think might have actually been in the initial brief is that the term auditor would include an audit, not of only expenditures, but also an audit of all revenues that are coming in and whether or not those are appropriate. Could you address those two issues?
Yes, Your Honor. As far as the custodian of the public funds, the county would say that if she takes those funds after the budget process is completed. So we have all these different roles under the statutory framework. And so the Board of County Commissioners is the entity that imposes the millage rate, levies the ad valorem tax revenue, and adopts the county budget. The role of property appraiser and the tax collector come in as far as assessing and collecting those funds. The role of the clerk and her role as custodian comes after the budget process. She receives those funds pursuant to the state constitution. It is our position that because she received those funds, she is not part of the actual imposition of the millage rate or has any oversight. If there is a overpayment or overassessment by the county, it is the county that's going to be liable as the taxing authority under state law. And there even has state statutes referencing refunds of assessments. If for some reason a taxpayer comes forward and says you overassessed me, there is chapter 197, I believe it is the refund statute. So
which is similar to what occurred in Marion County. You're familiar with that?
Yes, I believe so, Your Honor. I believe I'm familiar with that. So that's what our position is. The custodian angle is after. There's distinct roles in the budgetary process, and the clerk has no role in the approval of the budget or the millage rate or the levy ad valorem taxes. And she's trying to
in other words, your position is if we read the statute, read the constitutional provision, the clerk need not concern themselves, any clerk need not concern themselves with the legality of the revenues. All they need to concern themselves is here's the budget the county commission has duly voted on and approved and filed. And I need to make sure as the clerk that these funds are spent only in a legal fashion.
Okay, if I may.
Did you catch that?
I think I did. So yes, at this point, we believe that the clerk, and as a custodian, she is not the taxing authority. She is not the one that if a taxpayer contests an assessment, is going to have to come up with those funds. It's going to be the county. And there are cases on that issue where
let me say it a little more concisely. Your position is that there's no legal authority for the clerk to be concerned about anything that happens before the budget is duly adopted by the county commission.
That is correct. That is our position.
And that if the county commission does something that is illegal, that the ramifications will fall on the county commission and not on the clerk.
That is correct. There is case law out there about refunds, and sometimes there's a lot of money, and the courts have evaluated refunds, and that would be coming from the county, not from the clerk's office.
What about this argument that I think might have been sufficiently argued in the initial brief, that look at the word auditor, it's there in the law. The clerk is the auditor. Why does that? Clearly, it includes expenditures. The statute makes that abundantly clear. The statute, in my view, I can't find anything in the statute that makes it clear that it also includes the revenues. But why respond to counsel's argument that the term auditor just by itself includes a review of the propriety of the revenues? So
the auditor function, and if you look at the cases that were cited, that is the point where the clerk has taken custody of those funds and then is ensuring that the funds are either being held or dispersed appropriate. That's the auditor function. That auditor function doesn't start at this imposition of a millage rate or levy ad valorem taxation. That's putting the cart before the horse. That is the taxing authority that does that and then turns those funds over to the clerk of court. And therefore, she does have that role. But those cases are pretty clear. I mean, we had one involving a fire district where the funds had been put into an account the clerk did not have any control over. Clearly, she has a right to do an audit to see where those funds are and to make sure that they're being held correctly because they are public funds. But that's after the budget process, not before. Okay. So it is the county's position, because the county is the taxing authority, that we are the ones who would have any liability, that the clerk has no duty or obligation under the Florida statutory framework for the budgetary process or 2.9.3.1.
You think that the citizens of Brevard County, when they see a budget and it includes a one-time bump for, let's say the sheriff's office, that they think that's going to be lasting for the rest of their lives?
I have no idea what the citizens concern, but I will tell you that if the charter needs to be amended, it has to be a charter amendment voted on by the voters. And currently, as the charter language reads, it does not provide for that subtraction out that the clerk is seeking, and that is in subsection D of 2.9.3.1. So that is the county's position as it relates to the deductions that are coming out. So, it was the charter amendment was a special act that came into the residents and the voters of Brevard County voted on this language, and this is the language the county has to work within. But nowhere in here does it have a role for the clerk of the court to have some say or evaluation of how the millage is imposed or levied. And even this court in Ellis v. Burke held that it's the Board of County Commissioners, not the clerk of court, who establishes the budget and the millage rates via the statutory framework and the constraints of the Brevard County Charter. So the lawsuit that was brought in her official capacity, and that is really a point I'd like to make home, is that it was in her official capacity, not as an individual taxpayer. And unlike Markham, which I believe is the case where you saw the individual file as an official capacity and as an individual. And we believe it is barred by the public standing official doctrine, because she is at this point bringing it under that holding. She is affected by 2.9.3.1 because she is the custodian of the funds. She does receive a certain amount of funds.
But counsel, I mean, how is she? Fair enough. We've addressed the other issues. We might as well take this one up. How is she challenging the constitutionality of the charter provision?
Well, if you take a look, she does not use the words "I'm challenging the constitutionality" or validity. But if you take a look at the case of Markham, which I mentioned previously, in that case, it was clear at the Florida Supreme Court level, it was never raised the validity or constitutionality of the law in question. Instead, the individual was trying to get an interpretation of the regulatory language. The Florida Supreme Court said the language in question was clear, and therefore they found that there was the public official standing doctrine did apply, because even though they didn't use the terms "I'm attacking the constitutionality" or the validity, it was what the intent was, what they were trying to do. And when the language is clear, as it is in 2.9.3.1, as to how to deduct and what to deduct when you have a finding after a finding of critical need, at that point in time, it is a challenge to the validity of this.
You can see how we might struggle with the thought that asking a court to interpret language is the same thing as asking the court to hold it unconstitutional, right?
I see the struggle, but I would direct the court to the Markham case because that clearly is very similar facts as our facts are. And it is a Florida Supreme Court case. And they said it's not necessarily the words that the appellant is using. It's actually the effect that they're trying to accomplish, especially when you have clear language.
If they accomplish their interpretation, I still don't think that is in essence finding the charter provision to be unconstitutional. I mean, in other words, I mean, the charter provision will take effect either way. It's just a question of what is the impact.
It would direct the court back to Markham because I believe those are such similar facts that in that case, the Florida Supreme Court said, I mean, it was a challenge to validity. So her request for interpretation, I think, is well far afield from what the clerk's duties are. I mean, she has a role after the budget is adopted, and why she needs if she has no duty and no liability under 2.9.3.1, why she is seeking an interpretation at all.
If the clerk has no, is not a real party in interest, if the clerk has no legal interest, then does the public official standing doctrine even come into play?
If she correct, no, well, I mean, I think she fails on both accounts, but if she has no stake in legal interest, then obviously she cannot bring a declaratory action. But as well,
the point is that the public official standing doctrine issue becomes moot if she's not a real party in interest, correct?
Correct. I mean, I think she fails under both propositions. I don't think she has a legal interest or cognizable interest under the declaratory action. She has no duty and therefore can have no liability, as well as under the public safety of public official standing doctrine. She fails as well because she's affected, as well as at that point, she cannot meet the two limited exceptions under case law as far as the personal injury she cannot show, and the law in question does not involve the expenditure of public funds, and that is
wasn't the argument below primarily that under the public official standing doctrine, wasn't that really the argument that was made below?
That is correct, Your Honor. That is correct.
Mr. Andy, you were out of time. And thank you. Mr. Hull, we had a little bit of a lapse when we were online. I kept the time, and technically Mr. Andy got an additional 30 seconds, which I just let her take all the time. So I'm going to give you an additional 30 seconds as well. So you may proceed.
Thank you, Your Honor. And I'd like to start with the Markham case, because that case actually did, in fact, involve the validity of a regulation. And the First District Court of Appeal, at the very end of the majority opinion, expressly held that the regulation at issue there was invalid. That was something that the trial court had held, that regulation was null and void. And the First District Court of Appeal actually affirmed that at the very end of the majority opinion. And the problem is that was a regulation that Mr. Markham, as the property appraiser, was statutorily required to apply. And that's why the Florida Supreme Court reversed, because as a public official, he had to follow the regulation and couldn't challenge it. The suggestion has been made that the clerk here is trying to have a role in overseeing the budget setting process or in establishing the millage rate. And that's not what's going on here. The clerk here has a real concern about maintaining custody and spending funds that she believed were collected in violation of the charter. And the position that the county has taken here would require the clerk to blindly take custody of and blindly expend any revenue without any ability to audit it or without questioning its source.
I think that's probably an overstatement, right? No one is disputing that the clerk has the authority to audit expenditures. The only question is does the clerk have the authority or the legal duty to audit the revenues, right?
Well, the point that I'm making is that the county is saying the clerk cannot look into the source of the revenue and just has to expend it blindly. And you're right, when we're talking about looking at what are the expenditures for, that's a different issue than talking about what sources of revenue are we spending here? And the point that I'm making is that the county is saying that the clerk cannot ever look into the sources of revenue and just has to spend whatever funds happen to be in the county coffers without considering whether those were lawfully obtained or not. Without
I'm
the
not
ability to,
I'm not unsympathetic to the difficulties where if we were to hold that there was no authority of the clerk under these circumstances. Of course, again, a private citizen could have done it, but it puts you in a position in perhaps the middle or towards the end of an actual budget year of then having to freeze funds. Right?
Right. And that's the difficult position that the clerk found herself in, and one of the reasons for filing this case. And as you had identified at the very outset, this was filed before the adoption of the budget for that particular year. And we had mentioned at the motion to dismiss hearing some of the other facts surrounding why the clerk had brought that action, why the clerk understood that the county held that position. And that was something that was brought out the motion to dismiss hearing. But you're right; the factual background is not present in the complaint with respect to those particular issues. For example, I think we had mentioned that there was a county commission meeting where this issue was discussed and debated, and the clerk, gave the clerk's position. The Board of County Commissioners, gave their position as well, and so it was very clear who held what position. And made the case right for the clerk.
Yeah, but that doesn't necessarily make it a case in controversy, which is an issue that we're struggling with. Of course, again, if had you been allowed to amend, we wouldn't have that issue.
That's right. The case is certainly now at the point where that has made its way into the budget for 2021. The 2020 to 2021 budget and the 2021 to 2022 budget as well.
So that one extraordinary emergency expenditure now is got an ongoing life in perpetuity.
That is correct. That's the position the county's taken, and now that's what has happened with the budget going forward. Our position here is that the clerk, as a constitutional officer who is responsible for holding custody of the county funds, for auditing the county funds, and for dispersing the county funds, and not being able to look into the sources of revenue, is inconsistent with these constitutional and statutory duties of the clerk. So
what
wrapping
statute,
up,
counsel? I feel like I've been asking the whole argument for a citation, and the only one I've gotten is the word auditor. What statute applies to revenues? That would make this a lot simpler.
and I have to direct you back to the Constitution. It's the Constitution that gives the word auditor, that makes her the county auditor and makes her responsible for auditing the revenues. And I would add that in Alachua versus Powers, the Florida Supreme Court said that all audit functions belong to the clerk unless the Board of County Commissioners hires an outside accounting firm. And
I was
that's
just trying, because you said you included statutory provisions or reference to statutory provisions in the statement you made, and I just wanted to make sure that you can't point to a statute, right? You're pointing to the term auditor in the Constitution.
That's right. I'm not aware of a particular statute that addresses the auditing function with respect to the collection of revenue.
The Powers case never discussed anything to deal with the setting of the millage rate or the ad valorem tax rate. Is that correct?
I don't believe it did, to the best of my recollection.
Okay. All right, counsel. We appreciate the argument. I think it was a very lively argument, and it was well done. So thank you very much, and we wish you all
very interesting case and well argued by both sides.
Thank you.
Thank you.
Absolutely. Have a good day.
Have a good day. Thank you, guys.